Folks, we're back. This is Steve Sands and Stephanie Phillips with another episode of Veterans in Politics. Today we have Patricia Marr, candidate for Clark County District Court Judge, Family Division, Department D for
deliberating, divorce, determination. There's a lot of options there, but it is D.
Ms. Phillips.
Thanks for joining us, everybody, and thank you to our sponsors. We have Dr. Ari Nagy. He's running for Congressional District 3. His website is nagyforcongress.com, and that's F-O-R, nagyforcongress.com. We also have Henderson's mayor, Michelle Romero. She's running for re-election. Her website is votemichelleromero.com, votemichelleromero.com. We also have Cody K. Whipple. He's running for Congressional District 4. His website is codykforcongress.com, and that's the number 4, codykforcongress.com. We also have Dave Marlin. He's running for Las Vegas City Council, Ward 6. His website is daveforvegas.com, and that's F-O-R, daveforvegas.com. We also have Judge Jennifer Schwartz. She is running for re-election for Department 17. Her website is judgeschwartz.com, judgeschwartz.com. And we also have the Hangars Owners Association. Their website is vgthog.org. You can get in touch with Tim Ross and find out more about their organization and what they're doing. Their website, vgthog.org. Also, don't forget to grab your copy of Steve's book, How to Navigate Nevada's Family Court System. You can get a copy on Amazon. It is $14.99. If you are a family court litigant and you don't have an attorney and can't afford one, grab this book. It's a self-help book. It will help you navigate that system through family court. Also, we have a merch store. It's vipimerch.com. vipimerch.com. There's all kinds of fun things on there for you to check out. And also, we have some more joint veteran endorsement interviews coming up, which Steve is going to tell you about.
Oh, great.
Or am I supposed to? No, you go ahead. Oh, I went. Oh, okay, I didn't know what we decided. Anyway, you guys, all the candidates in all the other races, there are 66 of them, right? That
66
we have
seats.
So 66 seats. Everybody gets an invite. Watch your email. Watch your spam boxes, and make sure to RSVP. We're going to start on Saturday, March 28th is going to start the first round of interviews. And we're going to go for the next 6 weeks. And we're going to be doing Friday afternoons and all day Saturday. So hope you guys can clear your schedule. We invite everybody from all parties, anyone who has filed for a race. Not if you're not unopposed. I mean, if you're unopposed, then we don't. But everybody else, you will get an invite to come interview. And you guys know how that works. It's Facebook Live. We record it as well and put it on YouTube. And also you can sponsor those and advertise your yard sign. So get in touch with us on that as well.
No.
Anything? Did I leave anything out?
No.
Okay.
No. 66 races. So
Wow.
make sure these are for all the non-judicial candidates.
Mm-hmm.
But thank you, Ms. Phillips. Ms. Marr.
Yes.
Thank you for coming on the show.
Thank you for the invitation.
Absolutely. Could you give us a bio? Don't leave anything out, Ms. Marr.
A bio. Okay. I will start with I relocated from Youngstown, Ohio to Las Vegas, Nevada in 1985.
You've been here a minute.
I have, and I've officially been here longer than I resided in Youngstown. And I attended Kent State. I finished here at UNLV, switched majors from when I attended school in Ohio, switched and ended up with a bachelor's in psychology. And actually went to William S. Boyd by the time I was ready.
That's where you got your JD?
Yes, absolutely. Great school, great professors. I was fortunate enough to have Professor Bybee, who now sits on the Ninth Circuit. He was one of my professors, but we had great professors. It's a great school. Very blessed to have been accepted. And I'm even more blessed to have passed the bar and be in the position that I'm in. And I'm speaking about being an advocate. There's not one day that goes by that I don't count my blessings. in that regard: health, family, and my occupation.
So you've been practicing law since 2004.
I have, and I have a very diverse legal practice or legal background. I've done civil cases. When I first started practicing law, I worked for a sole practitioner, and it was not uncommon for him to take on these mammoth defendants where they literally back the moving truck up to the double doors in the front office and start unloading boxes for discovery.
Wow.
And it's just like you see on TV. And so I learned a lot. I got to second chair some great jury trials. And then ultimately I went to work for another sole practitioner where I started practicing family law.
So I just want to go through your education real quick.
Sure.
And your education and your practices area. You got a BA at UNLV, right?
Yeah.
You got a JD UNLV William Boyd School of Law, right?
Correct.
You practice in family law, criminal defense,
Yes.
civil litigation,
Yes.
personal injury,
Yes.
appeals and arbitration.
Yes.
Your courtroom experience is state, federal, appellate, right?
Correct.
Ninth Circuit Court of Appeals as well,
Correct.
right? And you won a case in the Nevada Supreme Court. Did you?
Two actually published decisions, and then I have writs, which are, in my opinion, they're difficult to get. And
explain what a writ is, and explain how difficult it is to get that.
It is. It's either a writ of mandamus, requiring the lower court, trial court, to do something, or a writ of prohibition, telling the court, no, you can't do that. We've always, in my opinion, and maybe I'm a little biased because I live here, but we have great judiciary in the appellate court. It never ceases to amaze me, as well as our judiciary in the lower courts too. And I always say, when COVID happened, everybody was working from home. My phone rang off the hook, and the court.
Why was that? Why did your phone ring off the hook?
Well, I suspect that because people had to live with their spouses like full time.
I want to get rid of him now.
Yeah, they couldn't. I mean, I was
Too close, too many hours.
I was surprised. I said, "Oh my God, the sky is falling, and you want a divorce? Okay, I'll help." But yeah, it was shocking. But Nevada implemented the blue jeans. I don't know if you recall that. So we could continue to do the hearings. And then now we have the Zoom hearings. But Nevada sprung into action, and Nevada has, they have one of the best resources for obtaining documents online, whether it's self-help or in some other regard. But hats off to Nevada. And again, I may be biased, but because I live here, but I've checked things out in other states, and we're very fortunate.
So you're also versed in high conflict cases. Explain what a high conflict case is.
High conflict cases are, particularly a lot of them. I did have the benefit of working for a firm in town. It's well known, and while I was in law school, and what surprised me was the fact that 80% of the cases were post-divorce decree litigation. People that can't move on, people that divorces are very emotional. It's almost like a death in some respects. It's you entered into vows. You never thought you'd be sitting across from a lawyer, dividing property and children and even dogs. So it's, some people have difficulty moving on, particularly when the other party already has. So it's a struggle. Some people have been abused in their marriage, and they are floundering. And I always encourage them, because we're counselors too, right? That you will see the light at the end of this process. I promise you that. And give it time. Some people use more Kleenex than others, but it's so rewarding when you see somebody blossom and find their independence after they've been either physically abused or mentally abused or both, and they just turn into like a butterfly and fly away and live a new life. It's so refreshing and rewarding, and I'm getting goosebumps. Sorry.
Do you see yourself being more partial to women or to men as a judge? How since you're a mom, you're a woman, you've experienced, you've had your life, would you be partial to one side or the other?
Absolutely not. No. You have to take people as you find them, and you have to. One of the difficult things about family court is they're in front of you or in front of the judge for a limited period of time. However, sometimes there's an evidentiary hearing or a trial, and so the trier of fact can assess the situation better based upon the evidence before it, including testimony. So it's it's not easy because, again, it's emotional. Some people don't do well in court. They have a lot of pent up emotions, and it's probably one of the most difficult areas of law to practice in. And a lot of people, this is, and I probably was guilty at one time early on in my career, like, oh, it's family court. No, that's so untrue. Mm-hmm. That's completely untrue. I think one of the difficult things also in family court is the lack of consistency. Sometimes I can go in one courtroom and get one result. I can go into a different courtroom with the same set of facts and get a different result. And so that's one thing if I'm elected to the bench.
Yeah, well, I was just going to say that. Why is that? It should not be.
Is
there that much discretion that the judges have that they can kind of just do what they want with those set of facts?
Well, they have parameters in which they have to work, but a lot of it is, to some extent, I shouldn't say a lot of it, but some of it is subjective, and one person can see something. It's like if we're out in the parking lot and we witness an accident, you might see one thing and you might see another. And so that's what makes it, aside from the high emotions, is that to some extent it is subjective, and you have to be on your game. And one of the reasons that I am running is because I represent a lot of my clients have limited budgets. And so they often come to me with their pockets empty after they've been somewhere else. And that's fine. That's
they
fine.
give all their money to somebody else and they come in and give you crumbs.
Crumbs are still food, right? So I try to help them. But what really bothers me is when there's a decision that I shouldn't say that I don't believe is right. And a lot of times the clients, they just don't have money to take it further to the appellate court. Mm-hmm. And so that's, but that's the same in civil cases too. Everybody has a budget with what they work within. Mm-hmm. So, but when it's family, when it's children, when it's, because the judges, a lot of times they don't see what we see behind the scenes. Mm-hmm. We've seen, we've heard the voicemails before. I mean, you can't throw everything at a judge like at the first hearing. It'd be really difficult. And so I think that's another thing that makes the practice of law challenging, or would be challenging for a judge, is you have to be on your game, so to speak, and be able to sift through what's being thrown at you. And again, it's always about the best interest of the children.
Mm-hmm. What if a lawyer comes in and you don't like that lawyer?
That's my problem.
Because there is, we hear all this, from people. Oh, that judge doesn't like me, or the litigant, that judge hates me, and they're not going to rule for me, and all of this. So how are you going to navigate that?
You have no choice but to remain impartial, because it's not about the lawyer. It's about the litigant that's in front of you. And you just, no, you can't focus on that. Of course, I would expect everybody in the courtroom to maintain professionalism. That would be a must. I've seen some situations get out of hand, which it makes it even harder on the litigants.
And they don't. Some of litigants we've seen, they do not behave. They act out. Attorneys, same thing. How are you going to handle those? Are you just going to walk out and take a recess and have everybody reset?
It depends on the situation. If it's warranted that maybe cooler heads could prevail, if everybody takes a break, maybe takes a walk in the hallway, maybe talks to their attorney where he or she might tell them, look, this is not getting us anywhere. Listen to what the judge is saying. It just depends. Every situation is different. I always tell my clients that your case is like a fingerprint. Your case is never going to be the same as your neighbors, your coworkers, your aunts. It's individual to you, period. I can tell you one thing I did not mention might not be on my bio, is I used to be an arbitrator for the Better Business Bureau for lemon law. And that was many years ago. And I always thought I was root for the underdog, typically, or I get drawn to the underdog because I want to help. But I thought this will be, I know I'm going to lean more toward, the consumer. And that was not the case. That was not the case because the consumer would come in but then, the dealership might come in, and you really have to listen to what people are saying. And the bottom line is you take the facts and you apply them to the law. And it's not as easy as it sounds. I was surprised at how I was straight down the middle on those lemon law cases. I'm like, oh, they make a good argument, but they made a good argument. Let me look at this.
Wow.
What do you think is the biggest failure in the Clark County Family Court?
In the family court? Oh, I think it's the fact that the courts don't have the time. I think. What do you mean by that? They don't have times sometimes to properly. They have busy calendars, and sometimes they try their best. I wouldn't necessarily call that a fault. I think we need more judges, probably, but I would say the lack of consistency. And again, I could go in one courtroom today, get one result. Could go next week to a different courtroom, get a different result. And it's frustrating. And it's difficult as a lawyer, I'm speaking as a lawyer, to try and explain to your client why what happened when it shouldn't have. But at some point, it sounds like an excuse in my mind. So you just, and a lot of times, you're throwing around legal jargon and they don't understand it. And it's difficult for litigants.
How do you fix something like that?
You appeal. You appeal or you get people on the bench that aren't biased and really listen and don't. And they may not even realize that they're doing it, to be honest with you. But you just have to listen. I'm from the Midwest, and so I think my values, I've carried them with me all of my life, and I think they serve me well.
How do you protect children caught in a high conflict custody battle?
In high conflict custody battles, you file...
And explain high conflict.
Oh, well, high conflict is, we all have different versions of high conflict.
In your opinion?
In my opinion, it's somebody that is just refusing to allow the parent access to the child, unilaterally withholding. So
parental alienation, you would consider that to be high conflict?
Yeah, they call it pathogenic parenting. And I can't begin to tell you, this is really difficult for people because they can't separate this division of the relationship that they have with the other parent.
So they can't see the trees in the forest.
Right. They can't see it. They can't see the damage that is doing to their own child or children. And
they have that much hatred for the other person. They just can't get past it.
There's a saying, they hate the other parent more than they love their child.
Yeah.
And and then that child grows up and it perpetuates, and then they have relationship issues because this is what they saw.
Children learn what they live, right?
Absolutely.
So how do you protect?
How do you protect them? As a judge or as a lawyer? I can tell you what I do as a lawyer.
As a lawyer.
As a lawyer.
Next year, you could tell me how you do it.
That'd be great. We file the appropriate motion. You do everything you can. You make your arguments. You file if it's necessary. You file it on an order shortening time. This past Christmas, I was dealing with a case where the police had to be involved, and it's not uncommon for us as family law practitioners to deal with that. But you do what you have to do. When I'm at work, and when I'm at home, I'm at work too. If that's what's required, that's what you do. Period. Okay. Because, a child that's in danger or a child that may be moved somewhere that you're really going to have difficulty finding that child, that doesn't stop just because you're at home. And maybe I'm wrong, but I said I'm blessed because I get to be in this position where I can help people and advocate for them. Mm-hmm. That's a big deal. And somebody said to me, they said something one day, well, you're an attorney. And I thought, wow, I am. I am. I can subpoena. I can do this. I can do that. I don't think about it like that. I just think about it as doing a job that I love to do.
You get to help people.
Absolutely. And you know what? I could pull my cell phone down and there's nothing more rewarding than somebody sending you a picture. Hey, I have my children back. Here's a picture of them. Look. And I'm like, oh, gosh, thank you for doing that. That just, yeah.
How are you going to enforce orders when you have parents who, they missed the pickup or the drop off, or they're not giving time to the other parent and they're just not following a court order? What are you going to do?
Well, there's always contempt that can be on the table. And again, it just depends on the situation. It might be where the other parent is consistently picking up late maybe they have a legitimate reason and maybe their schedule needs to be changed. And the other party's not cooperating. It just depends on the circumstances of the case. However, I do think that when people refuse to comply with a court order, at some point the hammer, the gavel has to come down, because there has to be consequences. But again, that's always with the backdrop of what's best in the best interest of the children. Mm-hmm. So you can't just yank a child away from a parent that may be misbehaving or not complying with the order to the detriment of the child, unless, of course, that child is in danger, because we never, ever, ever want a child to be injured or worse, ever. Mm-hmm.
So how do you ensure fairness when one party has all the financial resources and the other party has none?
Well, you listen. I particularly, I like when a judge will ask questions, because sometimes the court knows where it's going, and you may not, as an advocate. Maybe they have something, they're thinking about something, an option that I didn't consider as an advocate. So I don't mind that. But I think the courts pretty much, I don't think that money, I think the judges that we have on the bench right now, they're great about that. They obviously recognize somebody's walking in a mink coat, the person's coming in, dressed in a barrel with flip-flops. They get the picture. But as I said, the judges, in my experience, they don't let that become a factor in their decision making, and it shouldn't be.
I will not show up in a mink coat in family court
or a barrel.
No, be coming here with a nice clean polo shirt, some jeans, and that'll be it.
Yeah.
I'm not going to show my hand.
Yeah.
But do you think that when it comes to vexatious litigants, do you think that that's something that is unconstitutional, Or do you think that is something that is a tool for the court to kind of level the playing field?
I think, and I'm going to sound like I'll give you the lawyer answer. It depends. So a lot of times somebody that's representing themselves in proper person, they don't have the legal education. They don't to recognize what's relevant, what battle to fight. So they might just keep filing. But that doesn't mean that their case doesn't have merit or what they're trying to get across to the court. The relief requested doesn't have merit. They just don't know how to present it. So, and judges can't, shouldn't give it legal advice from the bench. But there are a lot of resources for litigants that can, where they can obtain help. So, but then you have the cases where it's like, come on, because at some point, there is a determinative factor. Like if you file a motion every day, you're just being vexatious. As I said, we have good judges on the bench. We're lucky. This community is pretty fortunate for the most part.
Yeah, Veterans in Politics had to help clean it up about 10 years ago.
Well, it's good. It's good to have watchdog groups.
Hold a few protests outside.
Just one.
Get rid of a couple.
To keep everybody on their toes, it should. The beauty of this profession, and I would surmise being on the bench as well, is every day you learn something new. Whether it's you learn something, I've represented physicians to policemen to dog groomers to, you name it. And I got to meet a lot of different people, lovely people, learn a lot about their professions. And it's just every day is a beautiful learning experience.
How do you plan on enforcing your court order when you put your court order out there and say pay child support here or pick up here, and the other litigant party in the case is not just flipping you the bird? What would you do? How would you enforce your court order? Is it something that's enforceable, or is it something that you're just not gonna pay any attention to it?
No, orders are orders for a reason. When the judiciary doesn't mean anything in our society, we're in trouble. If there aren't any consequences, we're in trouble.
What kind of consequences would you
Consequences, whether it's contempt. It's like I gave you.
contempt.
Pardon?
Contempt.
Yeah. If you give an order and the other party just refuses to abide by it, that's contempt.
What would you do as a judge?
Well, you have to have an order to show cause hearing, and they have to present evidence as to why they should not be held in contempt. And you get to judge the demeanor of the person that's before you, and they get to offer any evidence as to...
Let's say you find them in contempt.
Right.
Now what?
Well, it depends. Again, I know that sounds like the lawyer answer. It is. But it depends on the facts of the case. If it's really egregious...
Would you lock them up?
Yes. I wouldn't have no qualms about doing that.
And they say, Judge, you lock me up, I can't go to work, and I can't pay my child support, or I can't pay it, I'm gonna lose my job. What would you do?
And
be
again,
creative.
Be creative. Again, I would say that depends on the facts of the case. By way of example, maybe you, I'm saying this based on history, maybe you check into CCDC on the weekend and think about it.
That's what I wanted to hear. What days are you off, litigant?
Yeah,
oh, Tuesday and Sunday.
Yep.
Those are the days you report to CCDC, on Tuesday and Sunday.
Maybe when you eat that food, maybe you'll listen to the order.
For the next 3 weeks.
Don't say that about the food.
Some litigants get away with not paying child support for years. Some of them have the money. Some of them don't fill out those financial disclosures. And some of these judges that we have seen just kind of skirt over it and, it's not a big deal, and just allow this stuff to go on and on. Or are you going to be like that?
No, it is a big deal. And I can tell you that I have experience as a single parent. It is a big deal. If you're not receiving child support, maybe you could have taken your child to Disneyland. It's a big deal. It is. And we have orders for a reason. Our entire legal system is one of the best in the entire world, but it has to work properly. If we don't do what we're supposed to be doing within that system and all the checks and balances, and if orders are meaningless, we're no different than anybody else in the world, right?
True.
If the orders have to mean something, respect for a judge, respect for, the litigants and their counsel. It's supposed to be a place where you can bring your grievances and bring your requests for relief and be heard. And it should be adjudicated in an impartial manner, as expeditiously as possible.
What's your strong suit? Domestic, juvenile, what?
I would say my strong suit, I have practiced in abuse and neglect. I have practiced in juvenile court. I've done countless divorces, countless custody matters, and child support. And I probably the domestic at this point, because I've done so much of it. It's not uncommon for me to do one half-day trial, turn around, do another half-day trial that same day. I love it.
Well, let's switch gears a little bit. Let's talk about relocation of children, and let's talk about termination of parental rights. And a lot of people don't have stomach for either one of those. But do you think that one person, judge, should be able to terminate somebody's parental rights?
That's the way it's structured, is for the judge to make that decision. However, I can tell you that the person, or the parent rather, whose parental rights are being sought to be terminated is afforded every opportunity. It's analogous to the death penalty in civil court. And if you can't afford an attorney, you'll have a representation. It's a big, big deal. And it's not something that's taken lightly. And as I said, they're afforded every opportunity.
What happens if an attorney appears in your courtroom that's going through a divorce? How would you handle that?
Oh, you mean an attorney with his or her case in front of me?
They're the litigant.
Oh, just like any other person, that litigant that would appear in front of me. Absolutely. Okay. No favorites. Okay. No favorites.
Sorry, go ahead.
Oh, no, I was going to say, you know what, and that's probably, I could see how people are intimidated. I mean, first time I ever walked into district court, I was terrified. It was like 20 some years ago. And it's just so foreboding. I mean, the size of the courtroom, and it's quiet, and it's like, wow, this is it. So that's how litigants feel. Sometimes we can never lose sight of that fact. And another thing I tell you is really important, probably one of the most important things that a judge can do, or an advocate, is you have to listen. You have to really listen, not just become jaded and, oh, okay, what time's lunch, right? Mm-hmm. These are people's lives, their finances, and their children. This is the future. And one person is going to make orders that are going to affect the parties' everyday living. That's a big deal. Mm-hmm. Some judges a judge can, this is what time, if the parties can't decide between themselves, the judge will make the decision. This is what time you're picking up Junior. You may not like it. I mean, that to me, that's power that has to be, it has to be checked every day by the person that's wielding it.
So what does the best interest of the children mean to you?
The best interest of the children. Well, we have factors. We have 12 factors. We do not have 15 to 20 factors. We have 12. And
could you name them all?
I could. But to me, they're not exhaustive by any means. And one of the factors that is the most important to me is which parents willing to facilitate a relationship between the non-custodial parent and the child or children. And why is that? One of the most important factors to me is because you see the game playing every day. Whether it's subtle, sometimes it's subtle, but the children are affected. And, I'm not going to talk about my cases, but have had some really, really bad things happen when the other parent acts in a manner that is, when they just gameplay and withhold the child, or it can lead to dire consequences.
Let's talk about domestic violence.
Oh, yes.
So litigant A is saying litigant B beat her all these years, but she never filed a police report. No restraining order.
Fair enough.
No witnesses to support her case. No photos. No nothing. Would you go off of emotion, or would you go off of the chain of what they call it, chain of evidence? Or how would you handle something like that? Let's say this litigant says to you, I didn't file anything because
Terrified.
He would kill me.
Yeah.
Or I would lose my financial support, or I'll be out on the street, or there's always an argument.
Sure.
So how do you balance that?
Well, again, here's the attorney answer. It's coming. You ready? It depends. It depends. And it really does depend. How far in the past has the DV occurred? How far? And that's what makes this job difficult, not only for the attorneys, but I would submit for the judges too. That's where you watch a person's demeanor. You get them in front of you a couple times to perhaps err on the side of caution, but every circumstance is different. What I see, and this is what is really wrong, and I don't know the answer, is when you have somebody that's making false DV allegations. And it is a rebuttable presumption. Okay, there's a presumption that the parent that committed the DV is not suitable to exercise joint physical custody, but there is a rebuttable presumption. Like, say, dad cracked mom in the jaw like 20 years ago, and has been a model, has been a Boy Scout ever since. Well, you have to take the case where it's at when it's presented to you. Does that make sense? And another thing that's really troublesome that I'm seeing more and more of in my practice is when somebody makes false allegations of sexual abuse. There's nothing worse, in my opinion, because anytime you make a false allegation, whether it's DV, whether it's sexual abuse, it takes away from the resources that people that really need it and the children that really need it. But we live in an imperfect world. So, but that seems to be the flavor of the day, at least recently, that I'm seeing more and more of that. And I have ways of handling those cases as a lawyer that I'm not going to discuss, but I have some tools.
You're not going to divulge your secrets?
Nope. No secret sauce today. Sorry.
Yeah, I've seen that several times where one of the litigants will accuse the other parent of sexual abuse against the children and use that. I had a friend and went through years defending himself and ended up prevailing. But you have a degree in psychology.
I do.
So how does that help? It obviously has to help you determine and discern whether someone is being honest with you.
Well, I think the degree in psychology certainly doesn't hurt, but I don't intend to analyze people in that regard from the bench. I'm not there to be a therapist. I'm there to be a judge. And I think that there's no better substitute for experience, real life experience, and professional experience. And I have a lot of it. And I've sat.
How many years do you have?
Experience? I've been practicing since 2004. So math on a Tuesday, 22 years, and then about 20 years just doing a lot of family law, which I said I'd never do. I have a funny story if you want to hear it.
Sure.
I have a friend from law school, and I said, well, I'm going to do criminal defense when I get out. I'm going to be a criminal defense attorney. And she said, oh, I would never do that. I said, well, she said, I'm doing family law. I said, oh, I would never do that. She is doing criminal defense and I'm doing family law. Yeah, she works for the AG's office. We laugh about it. Yeah, she's still a good friend, but you don't know where. And now, like I said before, when I have clients that text me pictures, look, here's my children, and that's just not an isolated incident. I mean, that's a big deal. It's somebody took the time to thank you and show you. They wanted to convey their thanks to you. And I still have somebody said, oh God, this was years ago too. He said, I was just thinking about you. You turned it around. And if I wouldn't have my girls if it wasn't for you. And I'm like, oh my gosh, you remembered me? Thanks. Yeah, it means a lot. It's a big deal.
How do you stand out against your opponent?
Against my opponent? Well, I think the experience and Department D for divorce, determination, deliberation, as we've discussed, is distant, is going to be handling divorces and custody matters. And I think it's a learning curve. I think that distinguishes me in that regard.
A learning curve for who?
For the person that doesn't have that experience. And I think it's a job I would take it very seriously, clearly, but I think it's difficult enough when you're making, I shouldn't say difficult, but challenging when you're making such significant decisions regarding families that you don't want to be behind the eight ball, so to speak, coming onto the bench. And I think that my wealth of experience, seeing how the law is applied in real time, in real cases, and the nuances, I think that gives me an advantage for the bench.
You'll be ready to go day one.
Yes. If I can have this.
We'll have to get you one.
The nervous stick, right?
Are you going to welcome court observers?
Absolutely.
Because you know we will come observe.
Yes, absolutely. And since I threw my hat in the proverbial ring, whenever I appear in front of a judge, and I've been thinking about this a little bit before that, it's like, wow, I really like the way this judge does this. This is a really great skill that they have. This is a great strength. And I've been recognizing in different judges, their strengths and what they do so well. So I'd like to be a combination of all of those. Mm-hmm. So, yeah, we have some great judges.
Mm-hmm. We do.
What would you want people to know about you?
What would they want? Okay. I would want them to know that I have a great work ethic, that I listen. I think first and foremost, I care.